You're Janisha Jackson,
Yes, ma'am.
and this is 25 DCCR 0903. Ms. Jackson is charged with abandoning or endangering a child. And what is the announcement?
Your Honor, if I may, before we get to an announcement.
Sure.
Something on this indictment should be cleared up. In reviewing for the docket this morning, it's come to my attention that the body of the indictment, which is controlling, is correct. It alleges endangering a child. The style of the document is incorrect. The allegation under E is abandonment without the intent to return, and that is a second-degree felony. However, what Ms. Jackson is actually being charged with in the body of the indictment is 22.041C, and that's a state jail felony. So Mr. Lewis and I have discussed that this morning and on Friday as well.
Any objection to me making that modification to the style?
No.
I'll get that done so I have it correct. Give me just a second if I can do this. It's 22041C.
Correct, Your Honor.
Sorry. Okay, got that modified on the indictment. And so then what is the announcement?
Judge, we've talked about potential resolution on this matter, especially with that the amendment we've discussed. If I can get maybe a week or two with Ms. Jackson, so I can explain that to her and the ramifications of that, we'll be able to get it finished.
All right, we'll do about a 2-week reset. Ms. Jackson, make sure you call Mr. Lewis, make an appointment, go visit with him so that when you come back, we'll get an announcement, figure out which direction we're going to head on the case. Okay. All right, free to go. Thank you.
Thank you, Judge.
Thank you, Ms. French.
Window tent, window tent.
Okay, so y'all
Not-
already know that there's a warrant that doesn't have
I made
anything to do with this case, correct? Okay. Good morning, sir. You're Samuel Cadena?
Yes, Your Honor.
And Mr. Cadena was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. And I've received that pre-sentence report. Have you all had an opportunity to review that report?
Yeah, Your Honor.
Yes, Your Honor.
Any additions or corrections?
Nothing more of, Judge.
Not from the state.
And Mr. Parker, are you appointed or hired?
Hired.
Okay. All right. So, Mr. Cadena, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the fine of $500 and to follow all of the rules and conditions of probation. In addition to all of the rules and conditions that probation typically has, I am going to order that you are not allowed to consume any alcohol, and that for some amount of time you will be required to either wear a scram device or use a handheld device, whichever probation feels is appropriate. You can talk to them about the benefits of one or the other. I don't care which one, but you will have to have one of those devices. Obviously, if you test positive, it's a violation of your probation for alcohol. If you don't follow any of the other rules on probation, they're violations as well. This is an excellent opportunity because you don't have a felony conviction on the record. And if you successfully complete the probation at the end, the case will be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation. If you don't show up, and more specifically and concerning to me is if you test positive for alcohol at any time, then you will be back here in court. You can be found guilty of the offense and you could be facing a sentence of anywhere between 6 months and up to 2 years. Do you understand?
Yes, Your Honor.
If you have any issues with alcohol and not using alcohol, talk to probation. There is help that they can give you, but you need to ask for that up front, because if you test positive and then say, oh, now I need help, it might be too late and you could end up being revoked. Do you understand?
Yes, Your Honor.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Probation will talk to you before you go today. You will have to go with the bailiff because of that warrant, but she'll visit with you about what to do as soon as you're released from custody, okay? Good luck to you, sir. You can go back with the bailiff. Bass. And Mr. Bass is charged in each of his cases with aggravated assault, aggravated sexual assault of a child in cause numbers 25 CCR 0832 and 0833. And Mr. Rojas, what is the announcement?
Speaking with Ms. French last week, after exchanging emails, I think she needs more time to talk with the victims. It's a new case to her.
Sure,
She
yeah.
didn't have had time to look at everything yet.
Okay. Anything else that I need to know of, Ms. French, or?
No, Your Honor, Mr. Rojas expressed that correctly. I would want to talk with the family and the victim before an offer is made.
All right, so I'll just do a normal reset to give Ms. French some time to get that taken care of. She'll get that information and an offer to Mr. Rojas before the next court date. Make sure you stay in touch with Mr. Rojas so that once he has that information, you can go over it with him and we'll see if we can get an announcement at the next court date. All right, free to go.
Thank you, Your Honor.
Thank you. And then it's Mr. Bruce. Good morning, you're Julia Schultz. And Ms. Schultz was previously in court, entered a plea of guilty to injury to a child, a first-degree felony. I've received the pre-sentence report as well as I've visited with the attorneys. And for the record, we have also Ms. Randy King here, who is the assistant district attorney that handled the termination and CPS kind of portion of this case with regard to the children. I've received, has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to that report?
No additions or corrections.
Ms. Smolfino?
Judge, I would just ask the court, take judicial knowledge of the conversation we have had with the court and the understanding that this has been discussed at length upstairs. Ms. King has also provided me a tremendous amount of guidance, which I thank her and appreciate everything she's done with her wealth of knowledge and experience in guiding me through this case. I know the facts themselves are extremely egregious. It's difficult for all of us to look at. I would recommend Ms. Schultz is getting this opportunity because she has availed herself of certain things and tried to make progress. The children, her rights have been terminated, which she voluntarily gave them up, and they have been relocated out of state to a stable environment to where they will not have to testify against their mother, which was something that we took into a great deal of consideration. I would ask the court consider special needs safety in lieu of ISF cognitive. I think it is a more lengthy and a more appropriate term in custody as either an upfront type of sanction, but more so to give her the tools to be successful on this probation, because as the court is aware, and I'm sure Mr. Samuel has advised Ms. Schultz, and I do not mean this statement to seem punitive, but if Ms. Schultz is back before you on a violation of this probation because of this opportunity she's been given, the amount of time that the state will be asking for will be overwhelming.
Thank you, Ms. Smolfino. Anything, Mr. Samuel?
Yes, Your Honor. I understand the position of the state. However, I have to look at things from the position of the individual. The pre-sentence investigation report shows that she has no prior criminal history. It shows that she has no drug problem. There is a question about the alcohol. However, we believe that that can be done without the need of the inpatient treatment of the ISF. We believe that she's finally working. That is one of the most important things that she has to deal with in what she's gone through. She's experienced the trauma of relationships, and I think all of that is stated in the pre-sentence investigation report. But what you do not hear is the experience with the other partners of the children. She has carried this burden. She has tried to do the best that she could at the time. She's educated, she has a degree, but she has not been able to find employment. She's finally working, you know, and we just ask that this be held in advance for at least 90 days. That will show if there's an alcohol problem. That will show if there are other problems that she's experienced. She has been to a mental health specialist for counseling, and she will get with them again. And we believe that if that is a part of the order for mental health compliance and conditions, she can do that. But let her prove to the court that this is not just her as it is today. This is a result of everything that she's experienced in her life at this point. I just pray that the court will have mercy on her and give her that opportunity.
Well, Ms. Schultz, you're getting mercy today. You're getting mercy from these ladies as well as myself, if I go along with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on a couple of things. One, the horrendous nature of this offense and what you put all of your children through, all 10 of them, is beyond anything that I have seen in 30 years of practicing law. 30. And so you're not walking out of here today. My initial thought was some upfront time, but if I'm going to stick you in jail, then I might as well put you somewhere where you're getting some help that you need, so that when you are released, you hopefully will be able to be a productive part of our society. But whatever trauma you've been through is incomparable to the trauma that you've put your children through. So at this time, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I'm going to follow this agreement only because of the work that Ms. Malfino and Ms. King and your attorney have done, and the agreements that they've reached, and I understand why. Part of that is so that your children don't have to be re-traumatized and come back here for a trial and testify against you. I don't want to re-traumatize your children, and that's the only reason I'm really going along with this. So I will defer all proceedings, place you on probation for 10 years. You will be ordered to pay the $1,000 fine and follow all of the rules and conditions of probation. One of those is going to be that you enter and successfully complete the special needs safety program. You will be on the mental health caseload when you're released, and you'll have aftercare through Spindletop. That is now part of your probation. So if you don't follow through with any mental health services that are recommended through Spindletop or probation, that's going to be a violation of your probation. You will also be ordered to remain in Jefferson County, Texas. You cannot leave Jefferson County without permission. You cannot go anywhere near or see your children. You've terminated that relationship. I know they're with family. And so there's no Christmases where you show up or they bring the children down or anything like that. That's done. That's over. If you want to leave Jefferson County, it has to be with my permission, and I will have to know where you're going and to what extent and things like that. If you do everything you're supposed to do on this probation, I cannot stress enough what kind of opportunity this is that you're being given. If you, however, violate any condition of probation, if you're back here in court, obviously this isn't a case that I will ever forget. And Ms. Malfino will also, like she said, if you violate probation and come back in here, depending on the case, what you violated and how you violated, you could go to prison for anywhere between 5 years and up to the rest of your life in prison. Do you understand? Yes. I'm handing you the trial court certification that shows this was an agreement and I followed it. So you've waived your right to appeal. So you can go, that's for her. You can go back with the bailiff. Thank you, Ms. King. Thank you, Ms. Malfino, Mr. Singh.